Okay, good evening, everyone. It's a pleasure to have you all here. My name is Tanya Casas. I'm the Dean of Business, Arts, and Sciences here at Delaware Valley University. And it's my pleasure to welcome you to our One Health seminar series. Here at Del Val, we approach One Health from a transdisciplinary systems perspective that recognizes that the well-being of people and society, plants and animals, and the environment is interlinked and intertwined. And really our goal with One Health at Del Val is to change perspectives, to educate the public. Just right now we're in One Health Week, and we have a series of events organized for our students. We integrate One Health into our courses, and we also provide a One Health interdisciplinary degree for our students. We have an active student research program, and some of our students will do research that's relevant to One Health. And of course, we're concerned with outreach to the broader community, promoting awareness, concern, and action by our community and beyond that's related to One Health, particularly through the seminar series. And it's my pleasure tonight to introduce you to our speaker, Leland Glenna. He's a professor of rural sociology and science, technology, and society at Pennsylvania State University. He earned his PhD from the University of Missouri in 1997, a Master's of Divinity from Harvard University in 1992, and a BA from Hamline University in 1989. His research focuses on the social and environmental impacts of agricultural sciences and technologies, especially the role of science and technology in agricultural and natural resource policymaking. Additionally, he examines the ethical implications of democratizing scientific research. Glenna has contributed to reports for the National Academies of Sciences, including one on genetically engineered crops, and has served as the president of the Agriculture, Food, and Human Values Society. He's received several awards for his teaching and research, including the Gamma Sigma Delta Excellence in Teaching Award in 2018, the Agriculture, Food, and Human Values Society's Research Excellence Award in 2010, and the Rural Sociological Society Excellence in Research Award in 2024. So I'm really excited to hear Professor Glenna's talk, and I did want to say if you have any questions during the talk, please put them in the Q&A, and once he's finished, we'll address the questions. Thank you.
All right, should I get started here? Can people see? Okay, I'm going to assume everyone can see what I've posted here. So thank you for the invitation to do this talk, and I look forward to hearing comments from people and questions at the end. Oh, it's not advancing. There it goes. So what this comes from is, I'll give you a little bit of background, but in another slide, but just to give a little bit of context here. So in June, there was an announcement by the U.S. Patent and Trademark Office that they were looking for public comments on whether an experimental use exception should be established as a statutory law as opposed to common law. For those who don't know the difference, a statutory law is when a legislature or the Congress passes a law and it gets signed, or a bill and it gets signed into law by the president. Whereas common law is when it's discussed by the courts and a decision is offered by the courts. And currently in the United States, the determination of what is acceptable research on a patented technology is decided by the courts. And as we'll discuss a little bit later, the reason there's a reason why we're beginning to debate whether this should become a statutory law. So my goal of the talk is I'm going to introduce this debate on utility patents on agricultural crops. I'll talk about some of the brief history of utility patents and the current situation that is creating this challenge right now. And then I'm going to use a thing called discourse ethics to evaluate these competing claims, right? Because we need some way of evaluating when someone submits an argument for why there should be a statute versus why there shouldn't be a statute. We need some way of evaluating those claims. And so I'm going to use that as a way to do that. So just a little background on crops. So for those who don't know it, until recently, the United States and no other country in the world allowed patenting on living organisms. That changed in 1980 when well, I'll get to that in just a minute. But prior to 1980, there was still no way of getting a patent on a living organism, and that included agricultural crops. Now, there were ways that our government created opportunities to still have some sort of intellectual property. And so the 1930 Plant Patent Act is an example where, so if you took an apple tree and removed it from its roots and grafted it onto another root stock, and you're creating a different kind of apple tree. Or if you took a potato and used its cuttings to create something new, or even mutation breeding, right, where you'd blast it with radiation to see if you could cause a mutation. This was something novel, right? So we have to have some way of saying that somebody does something with this. They need to, the breeder who does this should get compensated for that effort. And so they created this Plant Patent Act. And that was where, for these asexually produced crops, you would get a patent that allowed you to charge a licensing fee for any farmer who wanted to buy it, or another breeder who wanted to use it to breed another variety, right? So now there were exceptions, right? There was absolute research and experimentation could be done on this. And it allowed for a limited on-farm seed saving, right? So if a farmer wanted to save some of the seed from the asexually produced crop, they could save it as long as they didn't sell it. They didn't sell the seed. And then the 1970, the Plant Variety Protection Act, this was a U.S. Version of a larger international agreement, the International Union of Protection of New Plant Varieties. But in the US, we call it the Plant Variety Protection Act. And this is a case where the plant breeders can get a certificate, right, to say that we produce something new and we should be able to charge a licensing fee for that. It's important to recognize that none of these covered the breeding technique. It allowed research exemptions and experimentation. It allowed farmers to save and replant seed. And very importantly, it allowed farmers and researchers to breed new varieties off of those existing ones. So if you could create a new variety, that was fine. That was called innovation, right? All right, so these were kinds of intellectual property. But you'll see in just a minute, they were not nearly as restrictive as a utility patent. Right. So in 1980, the U.S. Supreme Court decided that a living organism could be patented. This was a bacterium that was converted, genetically modified so that it would consume oil. So it would help to clean up in oil spills. And so the Supreme Court said that's a bioengineered being is something different. You can patent it. Then in 1984, the Patent and Trademark Office applied this to bioengineered crops. So genetically engineered crops could be patented. And then in 2001, the Supreme Court decided that even crops produced through crossbreeding could be patented. This could be a utility patent could be applied, right? So remember that these utility patents were broader than those previous approaches, right? Broader than Plant Variety Protection, broader than Plant Patent Act. And utility patents could include germplasm, plant varieties, genetically engineered traits, breeding methods. But more importantly, really, is it also included these bag tags. So when you buy a bag of seed from a Bayer, or what Monsanto was purchased by Bayer, or Corteva, there's this bag tag that says there are restrictions. You cannot save seed. You cannot do research on it. You cannot experiment on it. And it also, this prevents you from breeding new varieties, right? So it really locks in the ownership by this breeder who comes up with this new variety. And usually these are large corporations that are developing these new varieties. So is this good or bad, right? Are utility patents good or bad? And there's been this ongoing debate. Utility patents have been around in the United States since the beginning of the United States, 240 some years ago. The claim is that it promotes scientific innovation by providing the chance for inventors to benefit economically from investments in research and development of new crop varieties. The USDA has always promoted private investment, so they always wanted to extend into these kinds of patenting, these intellectual property dimensions. And you can really see this in 1986 when utility patents were applied to crops for the first time. This lawyer for Upjohn Pharmaceuticals made this very bold statement, the scope of protection needed to encourage investments for new plant breeding research, the rapid dissemination of information describing the new technologies resulting from this research. Now, that underlying thing here is a very important point. The rapid dissemination of information, right? This is a key part of a difference between a patent and a trade secret, right? A trade secret is, say, Coca-Cola, right? And nobody knows how to produce what the recipe and the strategy for combining the ingredients. And so you end up with Royal Crown Cola and Pepsi were trying to steal because they knew what the ingredients were for Coke, but they didn't know how to blend them just right? So that's a trade secret. And a trade secret can go on forever. But ideally, a patent, right? A patent is something where you release the information. So you get a monopoly on it. You own that property of that technology, but you describe how it's produced so that in 20 years, when the patent is ended, people will know how it's produced and they'll be able to innovate from it, right? All right, so there's this trade-off. So it enables inventors to profit. It reduces the efficient use of knowledge, right? So on the one hand, not everyone can innovate off of it immediately, but it also releases that scientific information. So you have these kinds of trade-offs going on. So it's important to recognize the goals versus the objectives, right? The goal is scientific innovation for social welfare. The objective is to give people an incentive to invest, right? We have to keep that right. The objective is to facilitate private interest and profit from research, but the goal is to improve social welfare. And it's important that we not mistake the objective for the goal, because I would argue that is a key dimension of what's going on right now. Is patenting has been developed to simply facilitate private profiting, as opposed to the goal of generating social welfare. And we'll see that tension a little bit later. So the research impacts, so a number of scholars have been studying the impacts of these utility patents. Number one is that utility patents hadn't been available for plant breeders until recently. And so it only took 2 decades for utility patents to pass all of these other plant variety protection certificates and so forth. Remember those things that provided a little bit less protection for the investor. And they passed them by 2006. So it took about 2 decades to become far more popular than something that had been around for 40 some years. And you can see that here, right? So the patenting on crops were introduced here in 1986, 1990, and there's none there right at the time. You see mostly plant patents and some PVPCs here, right? Then in 91, 95, you start to see the utility patents applied to cultivars. So that would be on things like BT corn or herbicide-tolerant corn or soybeans. And then in 96 to 2000, you see an increase in the utility patents. And by 2006 to 2010, the darker blue bar there shows that utility patents have passed Plant Variety Protection Act in terms of number of patents on them. All right, so do patents equal more social welfare? Right? If you remember, the goal is social welfare, not just generating more patents. So there have been some studies, for instance, Held and Chapman looked at this and they said, you know, if patenting enhances innovation, there should be more varietal development as an IP as patents become stronger, right? Because people will invest in more, whatever it's corn, soybeans, vegetables, fruits, whatever. You'd see more if this really is generating more social welfare. What they found when they looked at these patents was that stronger IP played little or no role in that innovation. They said they even found that more growth, they found more varieties being produced in crops with fewer patents. So one of those that they talked about was tomatoes. Tomatoes, for some reason, have fewer patents applied than some other crops. And there are more varieties of tomatoes produced than some of those crops that have patents. So their conclusion is that, you know, if you're talking about social welfare, we're not seeing it come here. Another dimension of social welfare is market concentration. Because the introduction of utility patents has been linked to the rise of concentration. Just two companies right now control nearly all of the patents on major crops in the United States and around the world, really. All right, so that's another dimension here. So you can see this. So if you look up here in the right corner, you see Bayer and Corteva, right? So Bayer used to be Monsanto and Bayer, and then Corteva used to be DuPont Pioneer. So on the left, you can see how there were more companies, 20 some years ago. But now after the mergers, you see Bayer and Corteva, and between the two companies, they control 71.6% of the corn seed market, right? And if you look down here at soybeans, you see Corteva and Bayer control 65.9%. Now, usually, a simple rule of thumb is that if four companies control 40% or more of a market, that market is no longer competitive. That means that you have a control in the market as that company to be able to set prices, basically. So what we see here is a clear oligopoly, just two companies. You know, in fact, you could almost see Corteva almost has a monopoly at 38.3%, and DuPont or Corteva almost has a monopoly in soybeans too, right? So we're talking in unfair market. So if we think of social welfare as having competitive markets so that prices are supposed to fluctuate according to supply and demand, we see here, we can look at utility patents that fostered this and say, maybe it's reducing social welfare. So yeah, this is what I've already said here. Research that I've done myself about how utility patents can be used to impede R&D. So in 2015, I had done a survey of some entomologists who did work on corn in the United States. And nearly 1/3 of those university scientists said that their research on the efficacy or environmental impact of a transgenic crop had been hindered by these utility patents. And then nearly 2/3 of university scientists that I interviewed or that I surveyed said that they would conduct additional research if it weren't for the restrictions imposed by these bag tags. So basically what they're talking about here is that you can't even do side-by-side comparisons, right? Now think about if you know what Wirecutter is or Consumer Reports, right? You'll take like laundry detergent or or dishwashers, and they do experiments to see which one works better. University scientists are not allowed to do that on crops if the crop is patented, right? You cannot do it. Furthermore, U.S. has had slower yield increases and more market concentration than Germany has. And a key difference here is that Germany doesn't allow patents on crops. Scientists explain that patents limited the use of transgenic breeding techniques, and they now limit applications of gene editing techniques, right? So we're beginning to see that maybe patents are not good for social welfare. There's just this increasing level of research on this. And so if some of you know Joseph Stiglitz's name, perhaps he was a Nobel Prize winner in economics. He and these other, his co-authors, looked at these, especially in agricultural crop utility patents, and they said nowadays it's widely recognized that the management of innovation in countries like the US has been suboptimal and led to situations that is increasingly litigious and plagued by conflicts, right? So they're beginning to, there's this increasing recognition that this just isn't working the way we had envisioned it working. So one way to think about it is we fixed it and now it's broke. Plant Patent Act was working fine. The Plant Variety Protection Act was working fine. Why did we need utility patents? All right. And that's really what led the Biden administration now in the last few years to start saying that maybe this intellectual property system is not working the way we want it to. So we need some way of, as they put it, in assessing that the intellectual property system, while incentivizing innovation, does not also unnecessarily reduce competition in the seed and other input markets beyond reasonably contemplated by the Patent Act, right? So are we seeing a reduction in competition? So that's where they introduced this public comment period. And again, common law, court decisions versus a statute. And they find that court cases tend to fall into two categories, some that enhances innovation by rewarding innovators with robust patent rights, while others noted that restricting research access to patented technologies would impede innovation. So we've got these competing court decisions, right? And it's leading to confusion and frustration amongst plant breeders, both in the public and private sector. And so this raises the question, maybe we need a statute that just says, look, we need a statute that says experiments can be done. We're not going to take it to the courts. We're just going to say it can be done. And it turns out every other nation in the industrialized nation in the world has this kind of experimental use legislation. The US does not. And so the question is, do we need that? Right. So the data that I used for this is there were 31 submissions to the US Patent and Trademark Office making a case for or against this statute. And I was one of those people who submitted. So you can just, I won't present what you've kind of seen what my argument was for that. I laid out the argument for how it was impeding research. But there were 30 other submissions. And so what I did was I downloaded those submissions and began to analyze them by their argument using Habermas's theory of discourse ethics. And just very quickly, discourse ethics is a way of evaluating the arguments presented. So one of them is, are they valid arguments? And there's two ways of thinking about the validity of the argument. The first is the empirical validity. Are their claims accurate and truthful? Do they have evidence to support them, right? A second is moral ethical validity. Are the claims about goodness, do they make claims about the goodness or the rightness of the policy? And this is where I get into issues of, say, are you really demonstrating that this is benefiting social welfare? How are those claims being made, and so forth? And I won't get into this. I'm noticing that the time is moving quickly here, but just basically it's a Habermas's justification for this. And yeah, so I talked about, whether they use ideology or these other rhetorical devices. Yeah, so an important part about the moral ethical validity, right, is one could make a deontological argument that people have a right to own things that they invent. But that is not the way the justification for patents is made in the law, right? The justification is in consequentialist terms. It's supposed to generate social welfare. It's supposed to generate social welfare. So any of these moral ethical claims where they're not talking about social welfare would seem to be that they are skirting that main fundamental issue. So that's one of the ways I evaluate some of the claims that they make. So yeah, so Foster, Tanya might remember John Foster from Cornell University, a professor there, and he used to use this discourse ethics to evaluate the way policies are debated, and whether people are using issues of misinformation, deceit, obfuscation, or abuse of power in the political process, right? So I use this to look at these assertions that these various companies make. So this is just a list of the various people and organizations that submitted comments to the U.S. Patent and Trademark Office. You see here there are 18 on the left. You see 18 organizations or individuals who supported the statute. They said, yes, we need a research exemption statute. And you see my name there. Some of them are small companies, some public breeders, some legal scholars, and I'll get into some of those in a minute. Then there are those who oppose the statute. And you see Corteva, right? The American Soybean Association, American Seed Trade Association. American Seed Trade Association is an NGO that represents companies like Corteva, Monsanto Bayer, and others. The Biotechnology and Innovation Organization, they also represent companies like Bayer, Corteva, and Amgen. What's interesting is Amgen is represented by a biotech innovation organization, but it's also, they support the statute as an individual company. And then there were 5 people and organizations that offered more complicated arguments. You know, like some said, you know, this isn't really the role of the U.S. Patent and Trademark Office to do this kind of thing. They shouldn't be doing this. So it was a more complicated argument than pro or con. So I kind of set those aside as a different matter. So those who oppose the experimentation statute were mostly large companies and the NGOs that represented those companies, right? So you had Corteva and Rice Tech. Yeah, so this is what I've already kind of talked about. And just this slide one more time, right? The market share of corn and soybeans, right? It's not surprising why Bayer and Corteva would not want an experimentation exemption, right? Anything that's going to reduce their ability to control 71.6% of the market, they're going to resist, right? It's just a pure interest, economic interest on their part. But this is another dimension of it, right? I think this is, you know, a very important slide. This was some USDA scholars, the same scholars who did the previous slide, where they show the seed price of basically these are the patented crops. So seed price index for GM crops, right? So the patent is introduced in 1996, you know, well, they're introduced a little bit earlier, but the crops go on the market in 1995, 1996, and you see these crops becoming increasingly more expensive, right? And you see the US seed price index. So this is all seeds, right? The brown or the tannish one. And then you see the seed price index for non-GM, right? So you see they start getting more expensive in 2005. You know, this is after the introduction of patents on non-GM crops, right? And the blue line here with the dots is that's the USDA crop price index. So what you see is that farmers are paying more for seed than what they're getting in their prices when they sell the crop, right? So it's hard to look at this and not say that there's probably some market control going on here that's connected to that oligopoly. You know, you could say, well, maybe farmers are paying more for these GM seeds, you know, these GM crops because it reduces their labor time or it reduces their on-farm management time. But it's also hard not to see that this is, you know, just a pure market power that's unfolding, right? There's no reason why it should be more expensive than any other seed, right? All right, so let's look at some of the arguments that Corteva made in their document that they submitted for why there shouldn't be one. They basically say, look, we can recoup our investments and reinvest in the next generation of products if we're allowed to maintain these utility patents. And not only maintain the utility patents, but not allowing for that research exemption, which is something even more kind of extreme. But what's fascinating here is really they're just restating a platitude, right? That patents are needed to justify investments. Well, that's just not the case if you look at how how you know, there were investments in seed innovations when there was just Plant Variety Protection Act. There's nothing unique about utility patents in terms of attracting investment. But furthermore, they say that they will reinvest in the next generation of products, and this is just simply false. If you look at so in 2024. Corteva actually used their profits to do a stock buyback. They put $1 billion in a stock buyback to drive up the price of their company's shares. If they really cared about research and development, they would have put that money in research and development, right? So there's something just downright misleading. Again, we're talking about this discourse ethic of evaluating that they're not being on the up and up here. Furthermore, they say decades of evidence demonstrate the efficacy of the current American intellectual property system, which offers parallel protections through strong utility patents and plant variety protection certificates. This is just an obfuscation because they're trying to conflate. They're trying to conflate the plant variety protection certificate with the utility patent. And then they claim farmers benefit. But we just saw the slide earlier about the costs that have gone up for seeds. Would farmers benefit more if there weren't an oligopoly, right? Yeah, it's just seems kind of rich. In the United States, by contrast, again, Corteva, the system of utility patents and PVPs allow open access to seed anyone who wants it after 20 years of patent protection. This is also misleading. Because as I'll discuss it a little bit later, there's something unique about crops here. Imagine you get a machine, right? A machine can be, let's say buying a tractor or something. A machine is complex, but you can reverse engineer it and figure out how to produce it if you're a good engineer. A plant is much more complex with incredible interactions with the environment, right? You've got all kinds of complexity going on about these crops. There's just not something that you can describe in the patent that you can lead someone to say, oh, I can rebuild that plant, right? You can't, it's a unique, there's a reason why utility patents were not allowed on living organisms. Because they're not created by people, right? They can be manipulated, but they're not created. All right. We would therefore view proposals to consider broadening the experimental use exception with grave concern, they say. And experimental use exemption could disproportionately harm, first and foremost, our nation's farmers. This is just a red herring they're making it, right? Claim it would harm farmers, not it really would harm Corteva's profits. It just, yeah. Right. So patents enable them to limit disclosure of information about their inventions, and it's not supposed to work that way. And I'll get into that in just a couple of minutes here. I know I'm running out of time, so maybe I'll just jump ahead to some of the counter arguments. Right. So basically, this really comes down to private interest over social welfare is their claim, right? And they're trying to avoid that moral ethical debate about social welfare. They're using claims about farmers to try to say that they're generating social welfare, but they're not addressing the fundamental issue that was raised by the Biden administration when they asked, is this limiting competition? Yeah, use misleading statements and platitudes. So let's look at some of the companies that are some of the people saying that this is inhibiting innovation. So Ginkgo Bioworks is a small company, and they say that the lack of a meaningful research exemption unnecessarily impedes the progress of science. They say that we need this to validate or reproduce the data and examples submitted by a patentee to support a patent's claims. We need to understand the characteristics of operation of a claimed invention. We needed to design around a patent. And that's the thing, they just don't allow, these current patents on crops don't allow someone to design around the patent even. So in some ways, what this company, or what this Ginkgo Bioworks is arguing, is that patents on crops are acting like a trade secret, right? Remember the distinction I made between a trade secret and a patent before? A trade secret is something where you don't share the information. Well, a patent is where you're supposed to do that, but they're using it as though it's a trade secret because they're not releasing all of this information. And that prevents the designing around the patent. Yeah, and so Inari is another small company that seeks to do innovations on crops. And they say the current state of common law experimental use exemption renders such availability meaningless. Again, what their argument is basically that a patent operates like a trade secret, the way it's being applied. Now, think back to the discussion I had about the university scientists who couldn't even do side-by-side research on these crops, or they couldn't evaluate whether a Bt crop was harmful to a beneficial insect because they weren't allowed to do the research on it. It was prohibited by the patent and the bag tag. Corteva is also suing Inari, claiming that they infringed on their patent. This seems to be a situation where they're just trying to, an absolute bar to research in any meaningful sense is basically what they're saying. So you can't even do the most basic research on it. As they say, such a statutory research exemption would ensure that transparency of deposited seed and foster competition by enabling new market entrants such as Inari to generate data and prepare to commercialize previously patented agricultural technologies promptly upon patent experimentation. So if you look at in the pharmaceutical industry, you can see how, let's say there's a drug that's very useful and profitable. And so other companies, there's generic drug companies that reverse engineer those drugs. They are ready as soon as that patent ends to release that generic, like the day after the patent ends, they release the generic variety. This is not possible in agricultural crops because the information isn't released. Okay. So this professor, law professor at DePaul University says, patents simply were never meant to convey a monopoly on scientific research, right? But only on a monopoly on competing or making use and selling market. This is an important argument. Essentially he's saying that the patents operate as a patent on the research as opposed to the technology. And another legal scholar, Janice Mueller, makes a very similar argument, right? If it were about innovation, the law would allow experimentation. If experimentation led to profit, the original inventor would get a royalty, right? There's nothing against giving a royalty. If a researcher comes up with a new variety off of a Corteva or Bayer crop, they could charge a licensing fee for it, but that's not allowed, right? It's just a way of preventing research. And then there's this group of public plant breeders who also submitted, and like this fellow Jim Myers said, some seed companies may not want their cultivars compared publicly with their competitors' material. And as the coordinator for the trial, I would be reluctant to include these cultivars because of their IP constraints for fear of being sued for violating terms of the patent. This adversely impacts the ability of growers and processors to make informed decisions and may hurt their businesses, right? if all product, again, I'll say this again, if all products were protected like agricultural crops, there would be no Consumer Reports and no Wirecutter comparing these things, right? And as his basic claim is, it prevents social welfare evaluation, right? In the plant world, it is essentially impossible to reconstruct a cultivar. This is the claim that, these are not like machines, like agricultural machines that can be reverse engineered. Living organisms are unique among patentable technologies in being self-reproducing, right? It's just current policy impedes social welfare is his basic claim. The public breeders also said even experimental uses that do have clear commercial benefits should be more clearly shielded from the risk of infringement, right? If someone comes up with a great new crop variety, why shouldn't we, right? If it's more drought tolerant, if it's resistant to, some sort of plant virus or some other, why shouldn't that be brought to the public's benefit? You can charge a licensing fee for the germplasm, but it's just I shouldn't be editorializing as much, but it's crazy. Yeah. So once a trade has near total market penetration, this significantly hobbles independent companies' ability to compete because they cannot incorporate these traits into their own germplasm, right? So this is another dimension of when a trait gets patented, you can't use it in your own germplasm, right? So patents effectively limit access to trait, not just to traits, not just varieties. And then large companies also arrange with smaller firms to limit their challenges. And it's as though the system is designed to limit innovation, is the claim. So in conclusion here, it looks like I'm close to being on time here. So empirical validity, some large companies are opposed to the experimentation statute. So it's a case where imagine if you have a technology on the market that could be improved and you don't want a competitor to improve on it. So what do? You make sure that the patent policy is so strict that no one can make a better product than you, so you don't face a competitor at some point down the road. They tended to offer platitudes and misdirection to distract from this fundamental phenomenon. And these collection of public breeders, patent lawyers, and small companies promoting innovation offered evidence and experience of how the innovation is limited, right? Yeah. So really, this is about that balancing that I discussed earlier. And the challenge is to balance the private interests and the social welfare, but the large companies are not addressing those concerns. They're offering platitudes and misdirection instead. The power of these large companies, they have more legal and market power. They have more lawyers on staff to win court cases, and they have oligopolistic control of the market, so they can set prices and limit competition. And they basically use, distracting from the question of enhancing welfare. By contrast, the collection of public breeders, patent lawyers, and small companies were describing how innovation is hindered, and their focus is on social welfare through innovation. So, yeah, I welcome any questions, comments, arguments, debate. Thank you.
Thank you, Leland. That's really fascinating. I'm wondering if you could talk a bit about what you presented was really a compelling case for the experimentation statute. Mm-hmm. What can the broader public do to support this?
Yeah, it's probably it's too late to submit a support in the public comments, but you could certainly write to your congressional representatives. You could also probably write directly to the USDA and say that, this seems very important and should be supported. But yeah, I would think, I talked about the paper that I wrote in 2015 involving the interaction with with entomologists. And I gave that talk back in 2014, 2015, and Glenn Thompson, my congressman from my northeastern Pennsylvania, was in the audience. And he was very interested in it. He came up to and talked to me afterwards saying, we need to do something about this. This seems like a real concern. But then I never heard from him again. I'm sure when he talked to his staffers, they said, yeah, well, Monsanto wouldn't want you to do that, so you better just stand. But I would still encourage people to contact their representative and say that they support this.
Mm-hmm.
Well, Leland, does this have any international impacts as well? We're talking primarily about the U.S., but does this impact food availability on a global scale?
Yes, absolutely. Good question. I would say in a couple of ways. Number one is the World Trade Organization mandates that any country that is trading with the U.S., if they want to stay on good terms, they have to honor our patents. So that means that even though some countries don't patent living organisms, they still have to honor U.S. Crop patents like this. But you also see it if any of you remember the nation of Mali began using some BT cotton back a number of years ago. And part of the reason why it failed so miserably was that Monsanto used their BT trait and bred it into a local variety that wasn't really good. So if they had allowed innovation, right, if they had allowed experimentation by local farmers or by people with some knowledge of the local crop varieties, they probably could have actually made it work. Yeah. So that's just a couple of ways, but yes, this definitely has broader implications. And if you notice, some of the companies responding to this call were Japanese pharmaceutical companies and Japanese interests. So there definitely has international implications for these policies.
Yeah, I would think the pharmaceutical industry would be rather miffed about agricultural seed production having these capabilities when they don't.
Yeah, you would think, wouldn't you? Yeah.
And that they in turn would have their lawyers working pretty hard to get that turned around as well.
Yeah. Agriculture is unique, right? It's as a sector, I think there's always been a little bit more power by some of the companies than what some of the. I think there's more competition in pharmaceuticals, number one, although probably not a lot more these days, but there is a little bit more.
So generally speaking, with this experimentation statute, is the idea that as soon as the patent is issued, you would have that statute right away, with the information
Yes.
released? Okay.
Yeah. So I mean, presumably the statute would also require that they fully inform what was involved in the patent. But then immediately scientists could start doing research on it. And it could be as simple as, in a lab on university, a graduate student seminar, where they say, we're going to do a comparative thing. We're going to see how this thing was created, because someday we might want to become plant breeders to use a technology or a technique similar to this one. So yeah, it could just be for training, curiosity reasons, and even that is not allowed right now. Well, it's kind of allowed, but you take a risk because you know that if these companies know that you're doing that research, they can take you to court.
So when they're granted a patent, do they have to prove that they've done particular research to demonstrate that it has no impacts on insects or the environment or what have you? Because it's incredible to me that they're not allowed to continue to do research.
That is a great question. I mean, the company has to release this information. They have to demonstrate to the EPA and the USDA that they're not having. So let's say we come up with a BT crop, but there's the phenomenon of, business information, protected business information, that they simply do not have to release all the information that they don't want released. So I have this other article from a few years ago, 2021, where I evaluated you've probably heard about all the lawsuits against Monsanto, and Bayer Crop Sciences is now responsible for all those because they purchased Monsanto. But in that paper, I used all during the lawsuit. Monsanto had to release all of their emails and documentation about glyphosate, what the risks of glyphosate. And when I started reading over that stuff, I started discovering some really fascinating stuff. And so I wrote this article about how Monsanto used ghostwriting, right, to flood the scientific literature with favorable research. So what they did was, let's face it, if Monsanto produces a paper, you're going to be skeptical of it, right? So what if you write this paper but you bring together a team of scientists from universities, and you have them read it over and make adjustments to it, and then they put their names on it as authors. And you, as Monsanto, don't have your name on your names. None of their scientists have it. So what you end up with is a ghost written paper that looks like it's a university study. And so when the EPA does its evaluations, you'd say, well, here's this, this is a university scientist doing this research, and they say glyphosate is safe. And so even in those documents, there was this email where this one scientist just protesting. He says, wait a minute, this is ghostwriting, and that's unethical. And right, the emails were right there. It's not like Monsanto didn't realize they were doing something wrong. So I guess the point is that it's so you might you have to release some information to these to the EPA and the USDA and even the FDA of whether this crop is safe, but they can very much control the kind of information that those agencies get. Yeah.
So we have a question here from Catherine Machalaba. Thank you for the great and very informative presentation. Adding to the international dimension, for countries without strong legal systems in place for intellectual property rights, any recommendations for governments and academic institutions in terms of local and indigenous crop varieties and fair use, leveraging access and benefit sharing guidance from the convention, the CBD, which the U.S. is not party to?
Yeah, that's a great question. Some of you may have heard of the yellow bean controversy, right? The yellow bean was, what was it, 2001, 2002, that a company in Colorado declared that a patent on a yellow bean. And this yellow bean had been produced in Mexico for like 200-300 years or something like that. There was nothing new about it. But this company had its legal resources, and they declared ownership of it. And that meant that Mexican farmers couldn't sell yellow beans in the United States without paying a licensing fee to this company in Colorado. Now, it turned out that someone had the resources and so forth to challenge this, and they got this geneticist at UC Davis, Paul Geptz is his name, and he did the analysis, and he said, there's nothing innovative here. You've basically gotten a patent on the color yellow, because that's the only thing about this bean that it's just yellow, and so you claim patent on. And so by demonstrating that there was no genetic change whatsoever, they were able to force the U.S. Patent and Trademark Office to revoke the patent on that. And really, that's what we're talking about here. You need to have access to the genetic research and legal resources to challenge these patents. Otherwise, you know, I don't know what else to, you know, yeah, we're at the behest of these large companies who have those legal resources. It's not a happy answer to that question, but I don't think there's a lot that company or that small countries or small farmers, indigenous farmers can do. You know, these companies can do their biopiracy and they'll get away with it until they're caught.
So did this person do the research kind of looking into this particular variety
Yeah.
outside of the United States, or yeah?
No, he was at UC Davis and he did the research here. Yeah. And he's an interesting guy. I know him. Yeah, so he did the research and I don't remember who hired him to do it. Someone hired him to do it. I think it was probably an NGO.
Okay.
I don't know the details of that. I should know the details to that, but I don't. But yeah, so that might actually be a strategy, is, you know, creating NGOs to challenge every patent that comes through. Would be another wave. Or maybe, you know, I happen to know a couple of people at the University of Wisconsin who are keeping these patent databases on crops, and some of them seem pretty weird. You know, like you're getting a patent on the color yellow or something, and so then they might be able to direct some scholar to do some research on it and to challenge the patent. That actually is, yeah, I mean, that might not be a bad strategy. We could maybe come up with some sort of a clearinghouse or something housed at a university where you could challenge these patents or something. Yeah, I hadn't thought about that till now. That was a good question. Whoever asked that, yeah.
So actually, the question that was brought up earlier is by our speaker that's coming up on the 21st of November.
Oh.
Catherine will be giving a seminar soon. I'm looking forward to that. Thank you, Catherine, for the question. Leland, I was also wondering about the court cases. So most of your argument here is about moving this from being determined by courts versus having legislation that actually spells it out. What are the arguments within the courts? You know, why this you know, not a very consistent cases there? Is this influence from the companies themselves on the courts?
Yeah, absolutely. I mean, as part of it is, you know, you get certain judges who are more favorable towards the industry than others too. But you've got to keep in mind the legal resources that these companies have. And I think a good example, there was this Pecklaner book. What was the title of that? I think I've got it here somewhere. Just a second. I can't seem to. Well, it was a book about how much power Monsanto has had. Now, Monsanto, of course, is Bayer now, but for so many years, Monsanto was the dominant player. But so imagine you've got a patented soybean crop, right, with herbicide-tolerant soybeans. Now, if it's patented, it means that the farmer cannot save the seed, right? So Monsanto has managed to get court cases saying that the germplasm is owned by Monsanto, and therefore a farmer cannot save seed and replant it. However, what if the seed's DNA spreads to another farmer's field just through drift? Now it's the fault of the farmer, right? So what you see here is that all of the benefits get privatized for Monsanto and all of the negatives gets socialized into the surrounding, right? So what their lawyers have been successful in these court cases of getting all of the benefits are privatized and the negative consequences are distributed to the farmers, right? From my perspective, that's just a clear indication of just how much legal resources are at play here in these court cases. When, well, we know this, you know, look at the tobacco litigation, right? For all those years, the tobacco industry could just file one motion after another, and eventually these small people who were filing lawsuits against the tobacco firms, they just had to give up because they couldn't keep up in the court cases, right? Because there was just one motion after another. And it's something similar here, right? No farmer could stand up to these companies.
So I think we've hit our time.
Mm.
This has been really, really informative, Leland. Yeah, I thank you so much.
Yeah,
thank you so much.
I realized at one point that it was too long and I should have probably kept it shorter, but I tried to speed up and I jumped through a few of them. I hope I made it in time here, and I appreciate the questions and comments.
It's been a great presentation. Thank you so much.
Oh, thank you. Yeah, it's been a pleasure.
I've had bits and pieces of this that I've picked up from the past, but you really pulled it together here very nicely.
Yeah. If anyone has any questions or further comments, feel free to reach out. You know, I think you saw my email at the end, or I'm sure, Tanya, I'm sure you could pass along that information.
I'd be happy to pass it along to anybody.
All right.
I also have it too, so if anyone wants to get that from either one of us, that'd be great.
Yeah. All right. Thank you so much.
Thank you.
Thank you.
Yep. Bye.
Everybody have a great evening. Good night.
Night.